Welcome, lawyers. Welcome to the Appellate Division First Department. We have over 6.5 hours of oral argument time. You've heard the spiel before. Please ask for the time that you need, not the time that you want. Maybe at about 10, we'll get to see the World Series. So I'll begin the calendar. People versus Trinidad.
Good afternoon. Appellant request 5 and 1, please.
5 and 1.
Good afternoon. Respondent request 6, please.
Okay, so see, 5 and 1 and 5. Gans versus Wilby Corporation.
Good afternoon, Your Honor. Appellate request 9 and 3.
Okay.
Good afternoon, Your Honor. Respondent request an aggregate of 12 minutes.
Okay, why don't we do appellant, let's do 7 and 2. And let's do 8 and see where we are. Remember, there's still arguments remaining, we're more than happy to hear them. We think, 7 minutes should be enough given the nature of this case.
Thank you, Your Honor.
Remember, we've read your briefs, we've read the record, we're very familiar, and you will see that with the issues in this appeal. So take that into consideration when you make the time request. R. Paul, submitted. J. G. Infant versus Fortress. Appellant. No appellant, okay. Respondent Fortress.
Respondent Fortress is here and willing to argue. I don't know if Your Honor has questions for us. We're happy to answer.
I think we're good. Usually I would ask you to go ahead and submit. We're familiar with the case. If you need to be heard, sometimes it's not a good thing to argue against yourself, because then you're going to get cross-examined.
I'm sorry we did not hear from plaintiff as to submitting. I would have, contacted the court in advance, but
Yeah.
I agree to submit.
Okay, so thank you. Thank you all. So J&J Infant versus Fortress is submitted. Thank you. Appreciate it. East River Park. I'm sorry, you petitioner East River? Okay. Okay, so let's do 6 and 3 and 6. City of New York versus JC Properties. Appellant City. Yeah, can you please keep your voices up so that I can hear you? I'm having difficulty hearing you. 6 and 3. JC Property.
Respondent 2 minutes.
Okay, why don't we do 4 and 3 and 2? Okay. Poliki versus 200 Park is submitted. People versus Nunez is submitted. Douglaston Civic versus City of New York, petitioner.
Good afternoon, Your Honor. Appellate request 8 and 4.
Obviously, you folks did not hear my spiel at the beginning.
I'm willing to modify.
Okay. Okay, City?
For the city, I'm happy with 5.
The developer responded in 5 minutes.
Okay. Okay, let's do 6 and 2, 5 and 5.
Thank you.
Pichardo versus Carmine Broadway. Appellant Pichardo.
Good afternoon. Appellant 5 and 2, please.
4
Okay, let's do 4 and 2 and 4. People versus Kinsey. Submitted. Tang versus Federal New York. Okay. Harry Spring Consulting. Let me hear from Appellant Spring Consulting. Let me hear from Appellant first. I'm not understanding or hearing what you're saying.
5 and 5, sorry. And respondents, 5 and 2, is it across?
Yeah, you have a cross appeal. So I'm going to give you 5 and 2 and 5 and 2. If we need more, we'll go at it. People versus Marco Alexander Aponte Cedeño. Submitted. And we have 2 cases, Arias versus Sanitation Salvage.
Appellant for the first variance, which is,
Okay, so Sanitation Salvage on the first one, right?
yes, appellant 4 and 2, Your Honor.
Do we want to argue those 2 cases together? We do, right? Okay, so let's do 4 and 2 and responding Arias. Tell me who you are.
Oh, sorry, respond.
So you're responding. Okay, so let's do 5 and 2 and 5 or both. Let's see if we need more than that, okay? Delibero is submitted. Castellano versus Ann Nassau Realty. Right, okay. These are 2 cases that were non-enumerated, so in my discretion, I assign time to let you argue. So Appellant Ann Nassau Realty has been given 5 and 2, and Castellano has been given 5.
Yeah, I'm also an appellate respondent.
Who are you?
I'm Ann Realty and PRG Construction.
Right. Okay, so,
We both appealed and both respondents.
so Ann Nassau Realty, right? You got BRF, and then you have PEC.
Yeah, but I have Ann Nassau Realty and PRG.
Right, so you'll get 5 minutes and 2 in rebuttal.
Okay.
All right? And I did that in my discretion. I didn't have to let you argue, but I did, right? So let's take yes for an answer. Castellano is responding, right? You get 5 minutes. DirecTV versus Nexstar Broadcasting. I have also exercised my discretion and given you time to argue. Nexstar Broadcasting gets 5 minutes and 2 in rebuttal, and DirecTV gets 5 minutes. I also understand you're going to have Pro Havishi counsel. Ms. Miniter, welcome to New York. Let's get the first case on the calendar, People versus Trinidad.
Good afternoon, Your Honors. May it please the Court. Molly Schindler on behalf of Rondell Trinidad. An upward departure to the highest SORA registration level was not warranted in this case. This was unquestionably a heinous crime. However, the question before the SORA court is about Mr. Trinidad's current dangerousness and risk to the public safety. The RAI result of level 2 reflected the conduct in both offenses and was
Counselor?
the correct, yes, Your
Counselor,
Honor.
Were there factors that were not taken into account in the REI,
Your Honor, with respect
which may have given a basis for the upward departure?
Your Honor, our position is that when you, the board's recommendation here scored, or rather the board's RAI scoring on the federal case took into account the conduct in both cases, and therefore there was no basis for an upward departure. So I do want to correct a misstatement in my reply.
But I thought that they added 30 points for the multiple victims factor, right? So that would have brought your client to 105 points presumptively, so that is considered a level 3. Am I missing something?
105 is a level 2, Your Honor, but it was the 95 points, that would have been the result that accounted for both
I
the
see.
conduct in both cases, which is solidly in the level 2 range. So that was the sexual contact with victim, 25 points for that, as well as the number of victims points.
But what about, for example, it's my understanding that when this gang rape occurred, no protection was used, and at least defendant, co-defendant were HIV positive, so there's a risk of infection for the child, drugging the child. Aren't those all factors that can be considered fairly by the court?
They can. I do want to correct the HIV point, Your Honor, because it was actually the co-defendant who was known to be HIV positive at the time of the offense. Mr. Trinidad found out later, several months after the offense, that he too was was HIV positive. He had sexual contact with the co-defendant during the same incident. So I don't think the causation in terms of clear and convincing evidence for that factor.
He didn't know the
quite clear.
co-defendant was HIV positive?
I don't know if that information's in the record. I don't think he did, but I don't want to misstate that. I think that if you score both cases, the conduct in both cases, the result is an RAI level 2. And I want to correct a misstatement in my reply brief. The SORA court scored them separately, and resulting in an RAI score of a level 1 on the federal case and a level 2, the lowest score in level 2 on the state case. So I apologize for misstating that. But it was the board and their recommendation, they scored them both together on their RAI for the federal case. And that's how you see that scoring the conduct together, accounting for both offenses, results in the RAI level 2. So that's the first basis for opposition to the upward departure. But the second basis is that when you move on to the final step of a departure analysis, you're looking at the totality of the circumstances, weighing any aggravating circumstance that this court may find against mitigating information, whether or not that information is already taken into account in the RAI. Because now we have no burden here, we're opposing an upward departure. And here there was ample mitigating information. These offenses took place in 2007 and 2008. Mr. Trinidad had never before been arrested. He was arrested for this case. He did more than 10 years in prison, which involved 2.5 years of treatment in prison for sex offender counseling, as well as additional outpatient treatment once he was in the community. He will be on supervision, intensive supervision in both state and federal until 2028, which is certainly something that was not in existence when he was committing these offenses in 2007 and 2008. And another very different factor is the family support, which was amply proven at the time of the SORA hearing. At the time of his offenses, he was distanced from his family. They had a tumultuous history. However, by the SORA hearing, they had developed very supportive relationships. The fact of his arrest came as quite a shock and a bit of a wake-up call to them all. And he spent his time in prison nurturing those relationships to the point where they were extremely strong members of his support system. His brother Manny, for example, they weren't even on speaking terms during the years that Mr. Trinidad committed these offenses, and yet Manny is the one who actually got Mr. Trinidad out of prison by finding him housing that complied with the restrictions. He had a very supportive family system. He was in an age-appropriate relationship with an adult partner by the time of the SORA hearing. These are all factors that show that we're now 13 and 14 years out from the time of his offense. He is not someone who poses the highest risk of recidivism, such that an upward departure to level 3 is warranted. So the REI result of level 2 was the accurate one here.
Thank you.
May it please the court, Beth Cublin for the people. The adjudications of level 3 were appropriate in both the state and federal cases here. And first, just because defendants' heinous conduct spanned both state and federal jurisdictions does not mean that he should not be assessed at level 3. That does not lessen his threat to society. And as far as the points are concerned, I believe it was stated correctly, but on the federal RAI, he was initially assessed 95 points because 25 points were assessed for sexual contact with the victim. However, the SORA court later removed those 25 points on the federal RAI because that only applied to the state RAI. So he had 75 points on the
How do you respond to your adversary's point that there's low risk of recidivism in this case, given family support, et cetera?
As to that, Your Honor, needs to be assessed in the context of the totality of the circumstances, and at step 3, weighing the aggravating and mitigating circumstances. And I will say initially that despite the point that was made, it is significant that those mitigating circumstances were already accounted for, both in the RAI and also by the SORA court. In the RAI, he was scored 0 points for his post-offense behavior and for his release environment, and the SORA court also already considered that information, and in weighing it in its discretion against the heinous nature of defendant's conduct and all of the aggravating circumstances here, came to the determination that it was correct to maintain the board's assessment at a level 3. And as far as those aggravating circumstances are concerned, in addition to just the concurrent offense, as far as the state and federal offenses, which is a proper consideration for upward departure, we also have several factors that the board states that were not adequately accounted for in the RAI. On the state RAI, that's the additional child pornography that the defendant received before the incident from the co-defendant.
And he got no point assessed on the factor 3, right? The number of victims?
Correct. On the state RAI, there was no assessment for the number of victims. Right, that goes to that because there were 2 due to that. And then additionally, there's additional emotional trauma that was inflicted on this 10-year-old child that's not accounted for in the RAI. There were multiple abusers here, 4 of them, who abused this child over the course of 2 hours. The defendant himself committed multiple sex acts against this child. He knew that the child was being drugged. He watched the co-defendant put pills in milkshakes. And there was additionally possible HIV exposure. He tested HIV positive approximately 4 months after this incident. It is not unreasonable to infer that he may have been HIV positive at the time of this offense, and the sexual conduct was unprotected. In addition, he took photographs of the incidents. He sent those photographs not only to the co-defendant the next day, but also a year later to an auxiliary police officer. He sent 8 photographs of this child, re-victimizing this child and continuing his exploitation, and also discussed with that auxiliary officer a year after this incident occurred his fantasies about 3- and 7-year-old children. And in addition to that, he had intentions to take further steps. He told the auxiliary officer he had access to the victim, and he said in his statement that he messaged the co-defendant for his phone number, evincing taking steps toward possibly physically victimizing this child again. There are additional aggravating factors that are within the child pornography scoring position statement. I won't go through those as they're within my brief, and I'll just say finally, as the board specifically stated, overall the gravity of defendant's conduct epitomizes a level of dangerousness to children that is a serious concern for public safety, warranting the highest level of notification requirements, and I urge this court to uphold that disposition. Thank you.
Thank you, counsel.
Your Honor, just very briefly, Mr. Trinidad is not receiving a benefit from his conduct being across 2 jurisdictions. Any supposed benefit is erased when you score both of the conduct on one RAI, which is what the board recommended in the federal RAI, resulting in the score of 95 points, which is solidly in the level 2 range. With respect to the third step, though, the totality of the circumstances, the prosecution argues that the factors we've brought up are already accounted for by the RAI, but that's not a relevant consideration when we're in the third step of a departure analysis that we are not asking for. In other words, we want the RAI result of level 2 that is an accurate assessment of his risk. When you're reflecting on the totality of the circumstances, that is all of the circumstances of somebody's situation. SORA is meant to be forward-looking. It's not happening at the time of sentencing. It's not only accounting for the facts of somebody's case, which of course are especially heinous in this circumstance. However, the court is also asked to take into account all of the other circumstances that have happened in the last 13 and 14 years. So when that is done, the REI result of level 2 is accurate. Thank you.
Thank you. Thank you both. Gantz versus Wilby Corporation, Bedrock and Silverstein, and Justice Singh has recused from this case.
Good afternoon, Your Honors. Joshua Bernstein from Ackerman for the appellants. It's nice to be back. This is my first in-person oral argument in 2 years, so I'm excited to be here today. As Your Honor knows, we're here today on a case alleging that a novel, years in the making, multi-billion-dollar development in Astoria that my clients conceived of and spent millions of dollars taking from concept to the precipice of fruition was usurped by the very entities that my clients were negotiating with to
Can I
form
ask you,
joint.
what was your client's interest once the pre-lease agreements had been terminated for non-payment? What interest remained that your client had in the project?
Sure, my clients maintained an interest with the Department of City Planning, with,
What does that mean?
my clients were in constant communication with John Young, getting the Department of City Planning.
But what was their authority once those pre-lease agreements were terminated to negotiate a deal with the city planning?
Sure,
don't
so I
understand that.
appreciate the question, Your Honor. My clients own a parcel of real estate in that jurisdiction. My client, that parcel of real estate was intended to be a part of the overall development. My clients, even after termination, and let's not forget how we got to the termination, because I think that's important. The termination, according to the complaint, only occurred because Silverstein and Bedrock induced the landowners to breach the exclusivity clauses in the pre-lease agreements.
I didn't see that. I thought you stopped paying the money.
No, absolutely not, Your Honor.
You never stopped paying the pre-lease payments?
Yes, if I can.
When did you stop?
What's that?
When?
For different landowners at different points in time.
And that was an event of default under the pre-lease agreements, right?
It could have been. It gave the landowners the option of whether to terminate or not.
And
Notably,
they exercised the option.
not correct, Your Honor.
No?
No, they did eventually. What the facts show and what the allegations are is that they did not exercise that termination right for months and months and months, while my clients and the landowners negotiated for a reset of the pre-lease payments. The reason for that is because Silverstein, as part of their proposed letter of intent for the formation of a joint venture, required, and this is right at page 456 to page 456 of the record on appeal, their letter of intent required my clients to reform the pre-lease payments under the ground leases before they would execute the joint venture agreement.
I noticed that you keep bringing in Mr. Silverstein, but in the context of the unjust enrichment claim, what is your relationship with Bedrock?
So Bedrock,
And why isn't it?
sure.
Attenuated.
I mean, sure. That was certainly the trial court's holding. Trial court's holding was that there wasn't a sufficiently close relationship with Bedrock and my clients. Obviously, there was with Silverstein. Trial court held that. Silverstein doesn't appeal that. I think given the NDA and the proposed letter of intent, there's no question about it. But with respect to Bedrock, that was the trial court's holding. That holding was not consistent with the allegations of the complaint, because the allegations of the complaint are that my clients were negotiating with Bedrock for the formation of a joint venture for this prospective development. In fact, the complaint pleads that my clients not only increased the value of the land by their years-long effort, but that Bedrock recognized that value that plaintiffs had created, that's paragraph 52 of the complaint, pleads that Bedrock sees that.
What does that mean? Bedrock recognized it. I mean, I didn't even understand what that means.
So what that means is that my client,
Is there a document that Bedrock said, yes, this property is worth more because of your effort?
I mean, because these claims were dismissed in the middle of discovery and the cases continued on, I can tell you that there are, but not attached to the complaint. There's a lot of documents attached to the complaint. Documents attached to the complaint definitely establish value. They establish it.
So your relationship with Bedrock are two people on opposite sides, like negotiating any other deal, right?
No, no.
Well, what else,
Sure.
what are you saying?
So the negotiations were with Bedrock were over the formation of a joint venture.
Okay, so you're on two sides. You obviously are trying to negotiate a deal. You're on this side, they're on that side. What is that? How is there unjust enrichment in that situation?
So what the case law talks about.
No, I want to ask you the facts. What
Sure.
facts are you saying gives a rise to an unjust enrichment claim between two parties that are on opposite sides of the table negotiating a deal?
Sure. So what gives rise to that is that the allegations of the complaint, this is paragraph, I believe, 50 of the complaint, are that not only did we provide Bedrock with massive amounts of due diligence concerning this project, but let me finish, Your Honor. I see you shaking. Just let me finish. But let me finish because it goes on. But not only did we do that, but Bedrock expressly agreed to keep those materials confidential and not.
I didn't see that. I have to stop you because I looked for that allegation in the complaint and did not find that. I found it upon information and belief, which
Yeah.
I
It's,
didn't
it's in
quite
your,
understand.
it's in your brief and in your reply brief, but I don't see it, I didn't see it in the complaint.
It's at page 43 of the record on appeal, paragraph 50. I see my time is up, but it's page 43 of the record on appeal, paragraph 50 of the complaint.
And says upon information and belief.
It does use the terms upon
How
information.
could
and
you
belief.
not know
I-
whether
I-
you had, how could your client not know whether there were facts supporting a confidentiality quasi-agreement with Bedrock? How could you allege that on information and belief?
So the reason for that, Your Honor, if I may, I see the red light is on.
Go ahead, go ahead.
Thank
Okay,
you.
thank you. The reason for that is because W&G was made up of two partners, Mr. Gans and Mr. Woolman. Mr. Woolman was the one dealing with Bedrock before he was bought out of the W&G partnership by Mr. Gans. And so that is the reason why it is alleged upon information and belief, because until we take discovery of Bedrock and Mr. Woolman, we can't be certain, but our understanding is that's exactly what happened.
Okay, thank you, Counsel.
Thank you, Your Honor.
You got a few minutes coming back later on in rebuttal, so I'm sure we have more questions.
May it please the court, I'm Kirk Brett. I represent Silverstein in this action, and the only claims that relate to my client in this appeal are the two tortious interference claims, and those are the ones I was planning on addressing. Mr. Sartorius is here for Bedrock, who would handle anything that I either forget, or, of course, the unjust enrichment claim, which does not pertain to my client, but pertains to his.
Okay.
And given the limited amount of time and the nature of the reply briefs, and the court's obviously familiarity with the briefs, I'd like to just address the notion in the appellant's briefs that only the claim for tortious interference for contract was assigned to W&G, and there's seeming abandonment of the notion that the landowner agreements or pre-lease agreements were assigned to them. So in the, in the brief, the argument is that on February 1, 2016, Quadrad assigned a claim for tortious interference with contract. They argue that there was an assignment of a tort claim, okay? And there are at least 3 reasons why that has to be rejected by the court. And by the way, this wasn't really argued down below, so that's why there's some of this is a little new for the briefing. But reason 1 is it's not alleged in the complaint at all. You can look in vain in the complaint for any suggestion that a tort claim was assigned.
I know they spend a lot of time calling your arguments, at least in the context of the tortious interference with prospective economic advantage. They call your arguments misleading. So,
As to economic advantage, Your Honor?
right.
Well, as to economic advantage, very simply, what is clear from the facts in the complaint are that Mr. Gans became involved in the project. The allegation in the paragraph, well, I'm going to forget the paragraph number, excuse me, but the first allegation is that he met with the landowners. And in that same allegation, the story is that he discovered they thought they were paid too much. And the next allegation is that he sought to renegotiate with them, but they rebuffed him. They did not accept the renegotiation. And then the third allegation is that he willingly, as a way of increasing his leverage, withheld payments from them. And then they responded, as the court knows, with the termination of the agreements as they were permitted to do. Thereafter, they either rebuffed or ignored his requests, his overtures. There is no allegation that they reciprocated any interest in this deal, doing business with him, as might be understandable based upon his negotiating tactics. And
But he claimed, maybe I misunderstood his arguments when I read the brief, but I thought he was claiming that that you were contemplating a collaboration, joint venture, at least with respect to W and G, and basically, unbeknownst to them, you were taking the material that they had given you and misuse it or misappropriate it or basically used it to compete with them. What do you say to that?
well, from a factual perspective, obviously we disagree wholeheartedly, but that does not support a claim for prospective economic advantage. He has to show and allege that but for the conduct of my client, the landowners would have re-engaged and done an economic deal with him. Okay, there's no way he can demonstrate that, and he doesn't even, there's no allegation of that.
Was there any allegation in the complaint about that at all?
I did not see one. I
They
looked for
didn't
but
say-
for
there
cause. I
wasn't-
did not
yeah.
see such an allegation, Your Honor.
Right? Other than, even if, were there any factual statements that could lead one to believe that that would have happened in the complaint?
No, Your Honor. In fact, I think the story is exactly the opposite. They didn't want to do business with him anymore.
That's basically,
wanna-
most of the claim is, they didn't want, that's basic,
Right.
that's their claim. You messed up our business relationship. So that's sort of antithetical to, we would have had a bit of business relationship, right?
Agreed, Your Honor, wholeheartedly. I feel bad. I'm nearly out of time, and the unjust enrichment claim hasn't been discussed, but Mr. Sartorius is here to address it if it pleases the court. Can I turn the podium over?
That's fine.
Okay.
I'll give him an extra minute.
Good afternoon, Peter Sartorius, Olshan from Woloski for Bedrock Real Estate Partners, LLC. I think the panel has a good grasp on at least one of the reasons why the trial court dismissed the plaintiff's unjust enrichment theory.
Can you describe, because this is pretty nebulous to me, like your relationship with Gans?
Sure. My client picked up the phone when Mr. Gans called, sat down at a meeting with him. Mr. Gans presented a proposed development plan. This is shortly after my client purchased its own parcel, or one of its affiliates actually purchased a parcel in spring 2016. Mr. Gans picked up the phone, or his colleague, Mr. Woolman, picked up the phone, called the principal of Bedrock, said, I have this proposed development in the works. I've laid some groundwork, let's have a meeting. They sat down, had a meeting. My client said, thanks, but no thanks. We already have our own development plans. Goodbye, we don't need you.
Counsel, did you enter into any kind of confidentiality agreement with the?
No agreement whatsoever, Your Honor.
Was there any?
There's nothing alleged in the complaint.
Other than on information and belief, right?
No confidentiality
And that party
agreement.
would have been there. The party that alleged it on information and belief would have signed that agreement or been at a meeting where that was agreed.
I would think so, and I would assume that it's a pretty important document to the plaintiff's case. If it did exist, they would have attached it to their complaint.
Did you
Well,
ask?
then the claim would have been for breach of agreement, wouldn't be necessarily unjust enrichment.
Fair enough.
So one other thing. You mentioned that when your client picked up the phone and met with Mr. Gantz, that Mr. Woolman was still in the picture. Is that true?
That's my recollection as to what's alleged in the complaint.
Is there anything in the complaint that's contrary to that, that would indicate that Mr. Woolman was not part of the negotiations that, at that time, such that, as your adversary said in oral argument, they wouldn't know about any confidentiality because that's within the exclusive control of Mr. Woolman?
Well, there was an eventual falling out between Mr. Gans and Mr. Woolman, but that was not later until later on in 2016, 8, 9, 10 months after the events that we're talking about here. So until Mr. Gans bought out Mr. Woolman pursuant to whatever partnership agreement they had, they remained partners and were both working together. I believe there's allegations in the complaint that both Mr. Gans and Mr. Woolman were both working simultaneously, cooperatively together to get whatever, progress
That something started, right? They had this plan that fell through, and they wanted to, I guess, enlarge it because that would have affected profitability, which apparently was an issue for the other landowners.
Presumably that's correct.
Yeah, okay.
Yeah. Justice Mendez, you had a question? No, you good?
There's no
Thank
other
you.
questions. Thank you.
I'm gonna have to lower this a bit. Not quite as tall as Mr. Sartorius. So first of all, I just want to hit on my colleague, Mr. Brett's argument. And with respect to standing for the tortious interference with contract claim, I think it's notable that Mr. Brett did not address the issue of waiver. The complaint pleads, and it is directly on point with the Todd Payments case from this court, a clear and unambiguous waiver by the landowners of the anti-assignment clauses in the pre-lease agreements, sufficient to defeat the standing argument that the trial court relied upon. Todd Payments is good law. It's 2015 case from this court. It stands for the proposition that a party to an agreement that accepts payments with knowledge of the violation of the anti-assignment clause waives the right to rely on it, the anti-assignment clauses. And that is true, just like in Todd Payments here, one of the landowners knew so much about the appellant's involvement, knew so much, that they actually addressed their termination notice to the appellants. And that termination notice is annexed to the amended complaint in the record on appeal. And it's annexed at page 462 to 463, as are a schedule of the payments from my clients to the landowners, millions of dollars that were accepted without objection. With respect to the assignment of tort claims, I just urge the court to take a look at shareholder representatives in Good World that we cited. Those cases are clear that on what an assignment of a claim is versus an assignment of agreement, and how an assignment of an agreement does voiding an assignment of an agreement does not void an assignment of claims. And then finally, I think, Justice Acosta, you were exactly right on the tortious interference with prospective business relations. That is our claim. That's what the complaint pleads, and that is more than sufficient under Martin Food Distributors, under Zaleron, TPP acquisition, and the like, to establish a claim for tortious interference. And then on unjust enrichment, if I could just be heard for 1 second. I know the red light's on. 1 second.
I'll give you 30 seconds.
Martin Food Distributors, which is a decision from this court, is directly on point. It addresses an unjust enrichment claim and the tortious interference claims with respect to a prospective joint venture partner that doesn't actually execute a joint venture agreement. That is this case, that is Martin Food Products, that's Ewan, and we think that we've stated a cause of action. I appreciate the court's time. It's nice seeing everybody in person again.
Thank you all. East River Park. Go ahead.
Good afternoon, Your Honors. It's really a pleasure to be here, and good to see you again, Judge Scarpullo. It's been about 10 years. It's rare that I start an
Are you
argument.
only happy to see her, not us? I'm disappointed.
We had a wonderful case 10 years ago. Saved 500 jobs. It was very good. It's rare that I start an argument by referring to my opponent's brief, but I think the essence of this issue is encapsulated in the way they framed it. They talked about on page 1 of their brief, Superstorm Sandy was a wake-up call. The storm devastated the city, including East River Park, Lower East Side, East Village. Water surged over the park's bulkhead, flooding the park and inland communities, damaging park buildings, etc. The city's plan is to elevate the park out of the floodplain and install a flood wall underneath, making flooding less likely. So I'm going to emphasize install a flood wall. At the same time, the city will renovate and modernize the park's infrastructure. The work to preserve the park also has another benefit, like a side benefit. It will protect the neighborhoods to the west of the park, since surge waters that cannot make it into the park cannot cause destruction inland. The city wants...
Counsel, are you suggesting that there can't be a dual purpose?
The purpose of the plan...
No, just answer that question. Can there be a dual purpose? It protects the park because it's going to lift the park up 7 to 8 feet, I think, and also
Yes.
Protect surrounding neighborhoods from flooding.
There can be a dual purpose, and that doesn't make it legal. And I'm going to skip just quickly to, because I think the Van Cortlandt Park case, there's a number of Court of Appeals decisions that make it really clear that the alienation concept is there's only de minimis exceptions. De minimis exceptions. The cases that are cited involve a bike rack, involve small little items in a park. And the 2 cases they cite about a restaurant, whether the restaurant is a park use or not.
I mean, in fact, most of the cases that you folks cited are not dual-purpose cases, right?
Well, but I think with the concept in Van Cortlandt Park, the Court of Appeals said, here the public will be deprived of valued park uses for at least 5 years, and this was supposed to start in March 2020. It still hasn't started yet, right? So they say 5 to 6 years. As the plant construction proceeds, while there may be a de minimis, that's their word, de minimis, while there may be de minimis exceptions from the public trust doctrine, the magnitude of the proposed project does not call upon us to draw such lines in this case. This is a project that, in the city's own description, principally it came about, and in the record, I think at page 330 to 333, the first letter that we have from the city to the federal government seeking hundreds of millions of dollars in federal funds, which they got and which they're going to use, says the proposed project is intended to advance coastal resiliency along Manhattan's east side.
I'm sorry, I'm going to stop you for a minute because here's my question. All right, I thought in the cases on alienation of park property that the issue that we look at is whether there is a park purpose to the work that's being done. And then that doesn't really turn on magnitude of the work, does it?
If it was only for a park purpose, it wouldn't.
Well, that's what you're asking us to hold. And I think that's what some of the questioning my colleagues is talking about dual purposes, that, can the concept of a park purpose kind of hold, 2 thoughts in your head at the same time? Can it accommodate a dual purpose if it's a park purpose?
But if...
And now I'm hearing an argument from you about magnitude. Well, if it was a single park purpose and the magnitude of the work was great, you're not suggesting that this would require state approval, are you? Just because of the magnitude?
If all that was being done here was to fix the park, we wouldn't be here, right? We wouldn't be here. And there have been park renovations all over New York City. But
without respect to the magnitude.
Not of this magnitude. I don't know, maybe in Central Park once upon a time. I don't remember.
But isn't the city obligated to keep the park for future generations? So that if we have questions about the ability to preserve the park, given some of the storms and some of the salt erosion and some of the other damages to the park, I'm just not understanding your argument.
Well, you know, the question, why is, the issue really involves, what is legislative approval, and what does it do for, why do we have it? Why do we have that concept? Why don't we just trust municipal governments to do things? Because when the legislative alienation process goes on and it's given approval, there's another body, an elected body, that has oversight over a project. Parameters are set, years are set, what uses are involved are set. And if they want to change that, they have to go back to the legislature and get it done. By the way, there is a case involving a dual project, the Stevenson case, where they wanted to, there's a landfill case and there's one where they were going to make a garbage. They were going to put garbage and make a ski slope. So it had two purposes, a place to put the garbage and then to create a ski slope. And the courts rejected on landfill to extend the park, on the garbage to create a ski slope. Here, what they're avoiding is the oversight of the state legislature. And all of the case law and the state's own documents, when Andrew Cuomo was the Attorney General, talks about how...
But that's assuming that the public trust doctrine is implicated, right? That's the only way that legislative approval will be required.
But again, there's no doubt. We say the principal purpose is a flood wall. The secondary purpose is to preserve the park, which they only talked about after the first 5 years of developing the plan. But the principal purpose here, if they were just doing it to protect the park...
I'm sorry, I just don't understand the argument, because as I understand it, if this flood wall doesn't go up, there will be no park. So isn't ultimately the purpose is to protect the park?
No, the principal purpose, this wouldn't be going on, this project would not be taking place if they were just protecting the park. They wouldn't spend $1.5 billion to protect the park. They're spending $1.5 billion to create a seawall to stop the community to the west from flooding. That's what they're doing.
Can the city, as part of the trust that has been given to it, both protect the park as well as the surrounding neighborhood, the buildings and the infrastructure around the park? Why are those two incompatible?
Why are they, it's not, the fact that there involves a park creates the alienation legislative requirement, because that's what we do in New York. You can't use a park, even partially, for some other purpose that's not a park purpose. And protecting the...
No, but I know you say it, but that's the question, right? It begs the question. Is protecting the infrastructure around the park a park purpose, if what it does is preserve the park for future generations?
No, preserving the infrastructure, the buildings, and from flooding and whatever, it's a very important purpose.
And therefore the park, you're just trying to isolate the park as if it's somehow unconnected
because
to everything else in that area.
For the first 5 years of this project, when they were going to do a wall, but a berm in the park, they said they needed alienation. They needed alienation. Then all of a sudden, 5 years later, so that was partly a park purpose, partly a purpose of serving the community to the west. Then they came up with this idea of raising the park 8 to 9 feet in the air. And
protect it, right?
Now it's a park project which has a side benefit of protecting a community. That was a way to sidestep the alienation requirement.
Okay.
Because that's basically our argument.
Okay, let me hear from the city.
Good afternoon. Mackenzie Fillo for the city. This court should affirm because the project plainly has a park purpose. And the fact that it will also benefit the neighboring communities does not negate that park purpose. A dual purpose project is permitted. This court held that in Petrosino, where the court basically said the fact that commuters would also use the bike share station did not negate.
But isn't this case is very different than that case? Wouldn't you agree? I mean, isn't counsel correct that the city, or wherever the money's coming from, $1 billion would not be spent just to protect the park? It's because of the benefit it has to the surrounding community why it's being undertaken, correct?
I'm not sure that we would be spending that much money just to preserve the park, but the fact is that every single thing being done in the park will protect the park and make it available to city residents for years to come. That's at page 1445 of the record. Every single thing being done in the park will help improve the park. Therefore, every single thing in the park has a park purpose, and alienation legislation is just not required.
Can I ask you a question? And it's really the inverse of what I asked your adversary, which is, if in a dual purpose project, if the benefit to the park, and there is a park purpose, but it is de minimis compared to the rest of the project, does that mean that you don't need state approval? I mean, in this case, you're arguing that there's a tremendous benefit to the park. It's the preservation.
Yes.
Well, suppose it was just, we're going to put up more trees. That's a park purpose, and the project is part of a larger overall project in the community. Would that require state approval, or does that come within your concept of the dual purpose? It's okay, it serves a park purpose.
It's just hard to imagine a circumstance like that. It's hard.
Well, it's exaggerated, but I'm trying to at least provide a circumstance. Do we have to be involved in weighing to what extent it's a substantial project that concerns the park or not a substantial project when we have a dual purpose project? Does that enter into the calculus?
I would say not under the current law. The law is that only things that have no connection to a park purpose are prohibited. Only things that have no connection to a park purpose require state approval. Here, as Your Honors mentioned in Mr. Schwartz's argument, the whole purpose of this project is to preserve the park. The park is dying as we speak. It floods regularly. The salt water from the river, which is misnamed, is killing everything in the park. The park will not be available for city residents if we do nothing. So this project has two very important benefits. One is to preserve the park, and one, yes, is to protect the neighborhoods that are adjacent.
So let me ask you, counsel, so you're not saying we're planting 3 trees to save the park, correct? You're saying that seawall is the one thing that's going to save this park.
That's exactly right. And in fact, it's just really hard to even imagine a project that would protect the park from the river that would not also stop river water from going to the west, right? I mean, the park is there right next to the river. So if the river water can't get into the park, then it also can't flood, the 10,000 NYCHA units right there. So there's just it's very difficult to conceive of a park that would meet the requirements that my colleague is suggesting apply here.
So you're saying that the benefit to the neighborhood is an incidental benefit, as opposed to the primary reason why you want to develop this project?
I would say they're both very important purposes in the project, and that even if it was considered a secondary purpose to preserve the park, that wouldn't matter as long as all the work being done in the park is work that will improve the park. Then, under this court's precedent and the Court of Appeals precedent, no state alienation legislation is required. I would also like to dispute my colleague's description of the Stevenson case. That case was not a dual-purpose case. That was a case where I think the county was going to operate a landfill for 5 years, and they claimed that in 5 years they might put a ski slope. But for 5 years, it was just going to be a landfill. That obviously has no park purpose. So that is not what we have here. If Your Honors have no further questions, thank you.
I think we're good. Thank you.
Your Honor, I think it's important, we talk about, the city relies on one case, Petrosino. And what was Petrosino about? Putting a bike rack in. That was what it was about. There was a fight over whether to put a city bike stand in the park. So the court ultimately held that that was a park purpose, that it expanded it had no other purpose except to expand the uses of the park. That's not what's involved. There's no other case. There has never been a case involving anything of this magnitude. And I think counsel honestly admitted You asked her, would this happen if there wasn't, would the park, if this was just for the park, to save the park, would we be spending all this money? And she couldn't say that. She could not say that. Because in fact, from 2012, when the,
No, but I thought I heard her give an explanation. Certainly they do, the city does in its brief, right? They're saying everything that they do, ultimately, given the language in Petrosino, contributes to or facilitates the use and enjoyment of the park.
right, but
The
so,
park won't exist 5, 10 years from now unless the infrastructure is built up, unless that flood wall
well,
is set up.
besides the fact that that's only established by an affidavit of somebody who initially wrote, the same person who wrote to the federal government saying it was a flood wall, it was a flood protection project for the community, the same exact person. Now she says, oh, it's going to save, the park survived fairly well after Hurricane Sandy. The park recovered after Hurricane Sandy without it having to be raised 9 feet in the air. Nobody came after.
So we have to wait till, listen, I live in Washington Heights, Inglewood, so I'm okay with floods. It's pretty high. But it looks to me, given what I've seen, that any continuous storms damage is going to, are you disputing that?
You know, Judge, I don't know, I don't understand why, it's one of the issues that we raise here. Battery Park, the lower Manhattan was totally flooded. My neighborhood, I live in the West Village, flooded all the way over to Hudson Street. That's why it's called Hudson Street.
Right.
The water was 12 feet high in Hudson River Park. If somebody said, we're going to build Hudson River Park up another 10 feet after we just opened it to save the park, it would be preposterous. This happens to be a plan which is next to one of the most, the poorest neighborhoods in Manhattan, lined with NYCHA houses, which, and for some reason, they said, for whatever reason, we don't really know, except to avoid legislative oversight. The only reason for describing it this way, for changing the explanation, no, in fact, they could have changed their plan. And if they put it through the state legislature, because that's all this is about, get legislative approval. We're not saying this isn't an EIS challenge. This isn't a secret challenge. This is a challenge that we're saying, whatever plan you came up with, you think this is a better plan? Have the state legislature vote on it. We have the support of the local assembly person and the state senator who feel that the legislature, given the dual nature of the plan, if we're going to call it dual, but given that it's a flood wall, it's designed to protect the community, given its magnitude, and given the fact that the park will be out of use for 5, 6, 7, 8, 9, 10 years, have the legislature weigh in on it. That's all we're doing here. Otherwise, it's totally a city bureaucracy plan. They can do what they want. The city council said, go for it. They go for it. No legislative oversight. Nothing of this magnitude. Like I said, the only case with a dual purpose, like Petrosino, which everyone called for dual, was about a bike stand. The other two cases they cite involve, was a restaurant a park purpose or not? This is not, we have a flood wall being built. We have a park being, even if you look at it as the park is now being raised to be a flood wall. That's not a park purpose. That's a purpose of helping the community.
Even if it is to protect the park,
even if
the existence of the park itself.
But they're not doing it to protect the park, because they would have never done this.
So you claim.
There's no proof that they would have ever done this just to protect the park. In fact, it wouldn't have happened.
Well, I mean, that's a high level of cynicism, but with respect to the city.
There's nothing in the record that shows that.
Okay, thank you. Thank you both. City of New York versus J.C. Properties.
Good afternoon, Your Honors. Deborah Kirshner for the City of New York Appellant, if it might please the court. When the lower court issued its order of $1.2 million in just compensation based solely on respondent's motion, it did fail to follow the eminent domain procedure law. And on that basis, the order must be reversed.
So I mean, that's the core of your argument, right? The EDPL is the exclusive procedure by which this is done, inasmuch as they didn't follow Article 5 of the EDPL, it should be sent back.
Exactly, Your Honor. That's the position right now. I could elaborate on the three main ways, but
Well, why don't you respond to the argument, actually, that since it arises out of the city charter, that somehow exempts this from the EDPL procedures?
Your Honor, I think you're referring to respondent's argument that the city here utilized ULURP as an exception to the eminent domain Article 2 procedures. The Court of Appeals in Grand Lafayette upheld the use of the ULURP procedure as an exception to Article 2. Article 2 procedures is where the city makes a determination to condemn. There's public notice, a hearing, and a determination. Because ULURP similarly has public notice, a hearing that considers the same factors, and a determination, it kind of stands in the place of an Article 2 hearing under the EDPL. It's only really within the realm of the Article 2 hearing that the ULURP becomes an exception. But in terms of vesting or determining compensation, that still follows the EDPL. Vesting would be under Article 4 and was followed here. And to the extent that there's a judicial determination of just compensation, that's under Article 5 of the EDPL. So the fact
So you need the exchange of appraisals, and you need the evidentiary hearing where the evidence will be weighed with respect to compensation.
So those two things did not happen here, but if they, but that's what we're asking should have happened here.
Right.
And because they didn't, the order should be reversed.
Okay, let me hear from the other side, see why we can disregard Article 5.
Good afternoon, Your Honors. I'm willing to rely on the briefs because nothing that I heard from counsel surprised me in any way that I feel I need to address further.
Okay, we good with that? Yeah.
Thank you.
All right, thank you. Thank you both. Douglaston? Sorry. This thing is balking on me here. Okay.
Good afternoon. May it please the court. My name is Jack Lester. I represent the petitioner appellants, the community members of Douglas. This case, it's an unprecedented rezoning of two discrete locations, two discrete zoning lots in Northeast Queens. The extent of the rezoning was so drastic, it had never occurred before in this low-rise community. As such, the City of New York designated this as a Type 1 action. What that means is that it has a significant impact on the environment because it's a Type 1. The city recognized that. What the city then did, however, was issue a negative declaration, which means that they did not have to perform an environmental impact statement. Now, why was that important? That was important because it excluded the community from public comment. It also prevented them from looking at mitigation measures. It also prevented an examination of alternatives. But most importantly, overriding all of these issues was that it excluded any kind of public hearings from
Mr. Lester, what about the fact that there was a hearing? Wouldn't that be sufficient for due process rights?
Well, there was a hearing at the City Planning Commission, which is part of ULURP. That's under the city charter, they must have a hearing under the rezoning.
So isn't that sufficient?
No, because, well, there are two things happened there. By the time it got to city planning, a negative declaration had already been declared. The environmental review process was already complete. But more importantly, and we bring this out, well, not more importantly, but as importantly, they violated the city charter in the way they gave notice to the community board. Now, that was of a piece of the fact that they excluded the community from the environmental review process. But
Is the community board a party to this proceeding?
the community board is not a
So
party.
then how do you have standing even to raise that issue with respect to lack of notice to?
Yes,
community board?
well, the Fleischer decision, which the respondents cite, is right on point, because a community member would have standing if the type of violation is such that can only be redeemed or addressed by a member of the community, and because the intent, the city charter intent, the intent when they formulated ULURP was to involve the community in the process. Notice to the community is supposed to be, and under the city charter, the purpose is to give community members notice. That the community board is the voice of the community. So I think the Fleischer.
And they participated, right? I mean, the fact is that they disapproved 24-0 and called the commercial overlay site spot zoning, right? That's the first context in which that term was used.
So that's a good point, because the community board did participate. They did address the issue. They unanimously rejected it, but they're only advisory. The real decision makers, the City Planning Commission and the City Council, and that's where the hearing needed, that's where you needed participation, because the real decision makers in ULURP, not the community board. Community board is just advisory, but it's the City Council and the City Planning Commission, and that's where the deficiency of notice creates a real impediment to the due process rights of the petitioners.
Don't we have case authority that says that a deficiency in the notice given would not by itself invalidate the actions of the City Planning Commission at a meeting?
Right.
Right. So the issue really to be addressed in evaluating notice, assuming we get beyond the standing issue, is the issue of due process, correct?
Correct.
So what about the various types of notices that were available and given was so lacking that it affected due process, even if we concede for a moment that it wasn't technically within the bounds of the statutory requirements?
Yeah, I think that's an important question, because in 1989, the city charter was completely revised in order to bring the community into the decision-making process. Prior to 1985, ULURP pretty much excluded the community. So the city charter went to great lengths, as well as the rules and regulations, to specify, to direct how the city should provide notice to the community. So this statute, which provided notice, is not just a technical procedural statute. This was the very issue that the New York City Charter Revision Commission addressed. That's the Constitution for land use in the city of New York. They created a notice provision.
Council, is it your assertion that the community board and the public had no notice of this hearing, or it wasn't full notice?
They had ad hoc, improvised notice. In other words, there's something in the record that someone from the Department of City Planning said something at an executive committee that they were going to have a City Planning Commission hearing. There was an email sent. These were all, it's ad hoc, it's arbitrary. It really defines arbitrary and capricious, because they created their own notice rules when the city charter very specifically directs how notice should be. And it's not technical, because the city charter went to great lengths when they put together the Charter Revision Commission. They spent a long time discussing and debating how the community should be notified so that they could appear at the city planning.
So council, it wasn't just at the meeting, right? It was put on the website. So anybody who went on the website got the notice of the meeting, and then it was published in the city record, correct?
That's right, but
So you get the city record plus plus the website. It wasn't somebody just said it at a meeting. It was
Right.
published on the website.
the community.
So you're saying that publishing it in the city record, publishing it on the DCP's website to people who, and clearly CB 11, Community Board 11, had noticed and discussed it. So what's the issue?
Well, first of all, they had discussed it prior, before the notice. But why that's so important is because decades of precedent, plus the way the process works, in order for the community to be notified, this is the process they relied on.
So I'm just trying to figure out what is missing besides publishing it in the city register and publishing it on the website. What are you saying was missing?
I'll read directly from the statute. It says, by transmitting notice to the concerned community board or borough boards and to the applicant not less than 10 days prior to the date of the hearing, and that was not done in this case.
Okay, thank you, Mr. Lester.
Thank you.
Hello again, Mackenzie Fillo for the city. This court should affirm, as to the notice provision, as your honors mentioned, there was more than enough notice. The petitioners here are not members of the community board. They are not injured by the fact that the city did not mail something to the community board. The city personally notified 3 weeks in advance the manager of the community board. That is more than sufficient to make sure that everyone is aware of what is happening. The city then, as your honor mentioned, published it in the city record, put it on their website, and 6 days before the hearing, emailed again to remind.
Let's assume it was ad hoc notice. Does the imperfect notice, does that somehow impair the validity of the decisions made under the city charter?
Not at all. In fact, my colleague here relies on, I believe it's 197CK, but 197CL specifically says that failure to post notice properly will not invalidate any decision of the city council.
Yeah, but L is a very specific provision, and that provision deals with the posting and not on a website where you take a notice, and in this case, you would be nailing it up to the trees in Alley Pond Park, right?
Sure, but here,
And so it's not pervasive to the entire statute. It's a concept that's in there if you don't do that nailing kind of posting, correct?
perhaps, but here there was more, they have no injury.
So, all I'm saying is that that provision that says that imperfect notice under L won't invalidate the actions of the zoning decisions doesn't strictly apply to this case.
I thought you would say yes. And
I would
just
argue
move
that
on.
it does, that's one of the notices that it's intended to apply to, but it does say post instead of mail, so I can see. But even putting that aside, everyone here knew about this meeting. Everyone here appeared. All the complaints were put on the record.
So would you agree with the answer that your adversary gave to my question, that when we're looking at notice such that it would invalidate the actions of the City Planning Council, we're really looking at whether it affects due process?
I would say yes, and here there's certainly no one.
So ad hoc notice might be okay if it satisfied due process, if it wasn't strictly compliant with the statute.
I'm hard to see how even the lack of notice would ever allow the overturning of the decision.
No notice.
I would think that what that would perhaps allow, it would excuse a petitioner from having to exhaust an argument by presenting it at a hearing, perhaps. But I don't think that failure to mail something 10 days in advance to someone who clearly knew about it could ever possibly justify overturning a decision of the city council. Especially here where we're talking about something that's so important to the city, we have a housing crisis. This is not unprecedented, as my colleague suggested. We're talking about 83 units of senior housing I think 30 or 35 of which are going to be permanently affordable in an area that has the highest percentage of older New Yorkers in the city. This is direly needed. And there was no problem with notice. We took the hard look. The environmental impact statement is very thorough. It followed the technical manual. All of that suggests that there's no reason for this court to be second-guessing the city's decision that these 2 unused lots should be developed into mid-rise apartment buildings on a block that is full of mid-rise apartment buildings. My colleague suggests it's just single-family homes for miles to see, but there is not a single-family home on this block. Once you go off the main streets, yes, it's single-family homes. But on this block, there are 6 or 8 mid-sized apartment buildings within a block.
5 to 6 story.
Right,
buildings.
exactly. 3 of the petitioners are 6-story apartment buildings. For them
Right.
to come in here and say that this is a single-family home neighborhood is frankly absurd. If your honors have no questions.
Thank you. Thank you,
so
Mr.
much.
Cansey.
Good afternoon, Your Honors. Benjamin Jolson from Ackerman for the 2 developer respondents. Mr. Lester mentioned that this is a rezoning of 2 lots. First of all, that's not accurate. This is a rezoning that affects 6 different lots. And as the city respondents mentioned, this is a rezoning that affects 3 lots that are already 5- and 6-story buildings. And this brings those existing non-conforming buildings into compliance. And that's important. Mr. Lester also mentioned that it's inconsistent with the neighborhood. That's just not true. At all of the meetings in the environmental assessment statement, this block that is being rezoned to allow for R6A is consistent with what is there. This is an area that borders Douglaston Parkway and Northern Boulevard. And Mr. Lester also mentioned that this was something that would have a significant impact on the environment. Well, that's the opposite. That was the finding of the negative declaration, that it would not have a significant impact. That's a 250-page EAS that was submitted. Just on the notice issue, very briefly, the record is clear. On November 14th, Scott Solomon, a city planner with DCP, personally announced during the CB Community Board 11 District Cabinet meeting to the district manager and a staff member that the City Planning Commission meeting had been scheduled for December 5th. So that notice was provided. It's also undisputed that the community board had actual notice, and we believe that the Ahern case and the Guyona case, they both hold that actual notice precludes a finding that an administrative determination should be annulled based on a notice defect. And if the record makes clear as well, at the meeting there were 4 speakers who read statements on behalf of residents of Community Board 11. There was 1 Community Board 11 member who testified in favor, and another Community Board 11 member who testified in opposition. So, and as on top of that, Mr. Lester submitted a 9-page written statement that was submitted at that meeting. That's at the record at 828. We agree with your honors on the standing issue as well. They're here fighting over a defect that was provided to a community board that is not a party here. So unless the court has any questions, I thank you for your time.
Thank you. Mr. Lester, I'll give you a few minutes.
I think what's missed is the context. First of all, this was a type 1 action. So if you look at all the case law, all the Court of Appeals decisions, which we cite, a type 1 action creates a presumption that there should be an environmental impact statement. That's to start with. And then there's a very low threshold thereafter to trigger an EIS. And why is that? Because the EIS is the heart of the whole SECRA statutory scheme. If you look at what SECRA is all about, it's all about mitigation, alternatives, involving the community. And you cannot do that.
Can I stop you for a moment on that environmental impact statement? In terms of the CPC issuing a negative declaration, is it your position that because it's a type 1 action, that it's a different standard of review by them in order to issue the negative declaration? It's not the same legal concept that we have of identifying relevant areas of environmental concern, taking a hard look at them, and making a reasonable elaboration for the determination. Do they have to do something different than that?
No, the type 1 action is what triggers that process.
But the process isn't an automatic kicker to an environmental impact statement. They're allowed to make a determination within the parameters that I just discussed about whether there should be a negative declaration. And if that is appropriately exercised, then, you know, where is there for us to
Right.
go?
It's not automatic, but if you look at the case law and the record in this case, did they in fact take a hard look at the areas of environmental concern that they would have been able to do if they had performed an environmental impact statement? And certainly on traffic, on the issue of parking, and on the issue of proximity to the wetlands. They take the position because it was not because it was not located in the wetlands that they were exempt from an EIS. But if you look at the secret technical manual, and that's the governing document to determine arbitrary and capricious, it's direct impacts or indirect impacts. So we presented to the court in the record all the areas where they failed to take that hard look, but the presumption is that they would have had to have performed an EIS. So that creates, they have the burden then of proof under the standard of all the Court of Appeals decisions. It would be different if it was a type 2 or unlisted, then a negative declaration could be sustained without the burden of proof that exists in this case.
Thank you, Mr. Lester.
Thank you.
Thank you both. Pichardo versus Carmine's Broadway.
Good afternoon, Your Honors.
Good afternoon, Counsel.
May it please the Court, my name is Matthew Blitt for Appellant Raul Picardo. One of the things I want to bring up here, outside of the briefs, is the focus on the decision below. And below, I think it's very interesting to note in the record is that the judge made his decision based upon what he believed wasn't enough here for a hostile work environment. And what he believed the standard was stated as, I don't get there on discrimination because I don't think his benefits were reduced. And that's the improper standard.
Right. You don't need an adverse employment action for a city human rights claim.
Of course.
Okay.
And, and I think also interesting in here is the judge also noted that this thing about the darker skin color and lighter skin color is definitely a racial thing. Wow. And then when you look at the record on how many times Mr. Picardo claimed, forget out whether it happened or not, he claimed in the record several times that this happened for a 4-year period and continuously endured it, continuously reported it to his supervisors, human resources, and ultimately—
I mean, your brief is very clear that just the fact that the people doing it or calling him names were Latinos, it doesn't mean that Latinos cannot discriminate against a darker shade Latino.
Nobody calls me a monkey. I'm Latino. I'm Cuban. But nobody calls me a monkey. It's based upon specifically skin color.
Right.
Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. Judy Shalmancy from Wilson-Elster for Carmines. I would, I don't know that I want to spend an awful lot of time on the judge's reasoning below because Your Honor's review is de novo, of course, of this summary judgment motion. I would like to spend a little bit of time on the claim that the complaints and the name calling and all those things went on for 4 continuous years. Because counsel makes that claim repeatedly and in fact did that on the reply brief, citing a whole string of case sites, the sites to the appendix. And I went through every single one of those because that is what I wanted to talk to Your Honors about. And not one of them relates to anything other than the clump of claims relating to 2011, which he said may have been early 2012, but in fact his complaint letters established were 2011. And then the other set relating to the 2 complaints much later after the 2-year gap. So I invite Your Honors to do the same. I'm happy to address.
Even if we just take those 2000, right? Those are within the statute of limitations, and clearly they're enough under the city human rights law, correct? You don't have to have pervasive under the city human rights law. You don't. It's not the same standard. So why aren't those 2 enough under the city human rights law?
Because, Your Honor, in context, it appears that they are not racially motivated.
Okay, but I mean, all right.
Why do you say that?
I understand and fully respect the idea that colorism can, of course, exist between people of similar racial backgrounds and all of those things.
Well, this is not racial. Latino is not a race, right? It's a national origin.
Of course, Your Honor.
So they are obviously different shades of Latino.
They are, but in the restaurant, there are actually shades of every color of African Americans who are much darker shades than him.
Except the dark-skinned guy is the one being called a monkey for 4 years.
Except he's not the darkest skinned guy in the restaurant, because they're African Americans. This restaurant has a
Wait
very
a second.
high
Are you
percentage.
saying because they don't call the African Americans monkeys that
I'm
that's
sorry.
okay?
No. I'm saying no. Your Honor, no. I'm saying that the reason they're calling him monkey is because apparently for 20 years he had been joking around with this one friend at work, and they say things that, by the way, Carmine's immediately condemned as inappropriate and told them, just stop it and call each other by your names, your actual given names.
But it didn't stop, right? And the arguments you raise, maybe they'll be accepted by a jury, but ultimately, isn't that really an issue of fact for a jury to decide?
Your Honor, my argument is
I'm limiting myself to what my colleague suggested, to the city human rights law, not the state.
I understand, Your Honor. So again, I think that given the context here and given that there are there are 2 claims relating to 2015, September, and the spring, and given the context in which they are occurring, monkey by itself is not enough to get us there.
Well, it may not be severe or pervasive, but it certainly is not slight and trivial, right?
Well, I actually think, Your Honor, that given that there is nothing else, it is slight and trivial. If you have a friend with whom you've been inappropriately joking for 20 years, it is, I respectfully suggest to Your Honors, slight and trivial.
Right. I mean, they dispute that, although they don't dispute the Balaguer response, right? Because the Balaguer response is even more complicated because the issues of sexual orientation being raised. So I don't even want to go there. That's for someone to find the facts, right?
Well, Your Honor, again, it's only these 2. Look, we have 2 things. Are some of them barred by the statute of limitations? And I submit that the answer to that is yes. And then that leaves us with the 2 mono comments. And again, yes, my position is, Your Honor, respectfully, is that given that this is not sort of the first level, like some of the cases that they cited, it was a cluster of horrible nicknames, amongst which was mono. In that context, it's a very different kind of thing. But here, where this is all you have, amongst staff of very, very, very different diverse backgrounds and skin colors, I respectfully suggest that it is insufficient to defeat summary judgment.
Okay, thank you. Counsel, I'll give you a minute. I think we got this.
I was just going to say, thank you very much.
Okay, thank you. Thank you both. Harry Spring Consulting.
Good afternoon, Your Honor. Douglas Pickensbeeke. We represent Harry Spring Consulting, LLC, and Harry Spring. The plaintiff appellant responded and defendant appellant responded in action number 2, and defendant appellant responds in action number 1. And we're arguing in support of our appeal from the amended decision and order dated March 12, 2021 of the court, which denied the Spring party's motion for partial summary judgment as to liability.
Counsel, can you explain to me why should we deviate from our settled precedent here? And in this case, I'm referring to the Panish ruling.
You hit the issue right in the head. The Panish decision is a decision issued in 2001. That, plus the Metaclaim versus Ruthius decision, are night and day to the fact pattern before the court. In those two cases, all you had was a situation in which a guarantor brought an action on the underlying note. In Panish versus Rudolph, the action was...
But aren't you, in essence, doing an end run? Because where do the monies come for buying out Citibank?
Your Honor...
Just answer that question. Where do the monies come from?
I have hearing aids, so if I could ask you to repeat that.
Oh, I'm sorry. Where do the monies come from to obtain the Citibank note?
Are you asking me why is Metaclaim distinguishable?
No, I'm asking you factually, where do the monies come from? Did Spring make the payments?
Those two cases don't have the fact pattern that we have in the underlying case before the court. What we have in this case is interceding bankruptcy proceedings, which wasn't found in Metaclaim and wasn't found in Panish. What we have here is an interceding bankruptcy court proceeding, which acknowledged various loan documents.
Counsel, you jump into a conclusion about what you think the question is asking. Why don't you stick to answering the question that is being asked of you? Who paid the money?
That was the issue that the state court judge concentrated on, and I agree with you. In the underlying decision, one of the...
Well, you have at least one judge in this panel who seems to be concerned, hence
yes.
The question, right?
And it's a very good question. The obligations was paid by the principal of Harry Spring Consulting, LLC. However, the fact pattern here makes that issue irrelevant and makes it distinguishable from the other two cases. Even though he paid it, and we acknowledge he paid it, he had the background of a promissory note. And the promissory note clearly...
So let's see. So he paid it. He forms a single entity LLC to then enforce the note. I don't see what the difference is in this case and Panish. I understand you're arguing with respect to the bankruptcy, but essentially all you're trying to do is an end run around our case law.
The decision back in Panish, which was issued in 2001, and made a claim that was issued in 2007, that relied on the issue as to who paid the monies, should be distinguished, especially in this particular case, because it doesn't address the arguments that we had brought up. In those cases, it was simple. It was black and white. There was, in the Panish case, the husband of the guarantor who paid the money. That was the source of the funds. He sought 100% of the monies to be paid back. It was wrong. I understand that. Same thing happened in Metaclaim, where the guy who contributed the money took the assignment of the claim and then sought an action other than contribution. I understand that. The court called that a line of cases that support the theory of contribution, that it didn't want reversed. The judge was wrong. The line of cases is two. There's also the...
No, but why is your case different? That's what we're trying to figure out. What do you think is different in this case?
That's vastly different.
How?
In this case, we've got issues of res judicata, collateral estoppel, law of the case.
Okay, so let me stop you on res judicata.
Okay.
Did the bankruptcy court rule on the relationship between HSC and the co-obligors? Anything, any ruling with respect to that?
Yes, what the bankruptcy court ruled on was that there was a valid transfer of the claims to the corporation. There's a finding in the bankruptcy court that HSC holds the claim. Now, if I can't rely on a bankruptcy court order, clearly an affiliated court, so to speak, with the ability to render determinations, if I have to start over in the Supreme Court, that's a problem. If they have waived all the defenses in the bankruptcy court and said we have no defenses, and then come into the Supreme Court saying we have defenses, that's a problem. Did they misstate the law and the facts to the bankruptcy court judge and then utilizing a different set of facts in the state Supreme Court? That's the problem. Here we have an acknowledgement of the transfer of the claim. Here we have a document that clearly says that there was binding on the bank's successors and assigns. Those arguments were never made. Never made in Panish, never made in Mediclum.
Okay.
This particular case.
I think you responded to his question, Counsel.
Oh, I apologize.
That's
Thank
okay.
you, Judge.
Let me hear from your cross appellant.
Good afternoon. May it please the court. My name is Jonathan Nelson, and I represent respondents and appellants on the cross appeal, Jack Easterson and Pamela Jerome. I think at its core that my adversary's misunderstanding of this case vis-a-vis Panish and Mediclaim is that both of those cases say that a co-guarantor is limited to a cause of action for contribution. You can't sue under the note.
So that, because in that way you can, if you could sue under the note, then you could get 100% rather than your percentage, right?
Well, that's
the
right.
whole
Not
point.
only that, you get
And the bankruptcy court never
interest.
said you can sue. There's nothing in the bankruptcy court order. The bankruptcy court allowed the purchase, right?
That's right.
And that's it.
That's it.
Nothing that said, sure, you should get more than contribution if you do this.
No,
right?
nothing.
That
nothing.
didn't talk about it. It wasn't raised before the bankruptcy court, was it?
No. And in fact, if it were, the bankruptcy court has to follow New York law. Would have to follow this court's decision in Panish. And so if there cannot be an action under the note, then I think my adversary's misunderstanding lies that a waiver of defenses under the note becomes immaterial if you can't sue under the note. You're stuck with contribution. I'm not going to belabor that point. I think that that point has been made through the brief. So let me now focus on the second action and my appeal. So that action really is focused on Mr. Easterson and Ms. Jerome alleging breach of contract and fraud and breach of fiduciary duties. And that's where, by the way, Harry Spring does make a counterclaim for contribution. That's the correct cause of action. And it's not disputed that after the meeting with the bankruptcy attorney, it was agreed by Mr. Spring, Mr. Jerome, Mr. Easterson, and Ms. Jerome, that WASA should be operated for limited purposes, to bring in revenue, pay down debt. Let's just wind it down. And so it's also not in dispute that following that agreement, Mr. Easterson and Ms. Jerome left WASA with that understanding. So the problem then arose when Mr. Spring decided, forget that agreement, I'm going to make a go of it. I'm going to try to revive WASA and tried to do that, and obviously it ended up in bankruptcy. It was a bad idea. But the problem really arose is that the revenues and the monies that came in weren't used to pay down the debt. How do I know that? Well, we know that because we found a bank account that was not disclosed in bankruptcy. You know, hiding information may be a pattern here, but be that as it may, it wasn't disclosed in bankruptcy, but we found it. And we found the garage payments and the
Counsel,
secretary payments.
what is your cross appeal on? It's not that.
No, it's this. All the information that we need to defend against the contribution was on one computer.
You have the counsel. You have the bank account, right? You have the bank information.
But Judge, the problem we
What
have,
else do you need? Let's talk about that.
all of the accounts receivables that may not have been collected.
Okay, so you can get that information, you may be able to get that information from the accounts, right?
No,
What else?
because all of
What
the
else besides the accounts receivables?
Well, let me just answer that one thing. No, we can't get that because the only thing in the bank accounts were monies that came in. What about the monies that should have come in that were not, you know?
Okay, let's put that aside. What else?
That's the main portion of it.
Okay, what
Because
else?
we do have, from the bank accounts, we have the money that was expended. We don't know if there were other accounts, by the way.
I mean, you could take depositions. I'm trying to
We
figure
did.
out, what is it that you think that you cannot absolutely in any other way find out?
Two items, two categories. Number one is the accounts receivables that weren't collected. Number two, the details of the expenditures, because we did take
Can't
depositions.
you take a deposition?
No, we did. We took a
Can't you
deposition
show
of
him
this.
and say, what was this for?
We did.
And?
We asked the CFO and we asked Harry Spring, and the answer was, I don't know, I don't remember. And so all the information that we would need to defend against a claim of contribution based upon the theory that the money should have been paid to pay down the city bank was on this computer that Harry Spring had that, I don't know, I don't know what happened to it. He says it got corrupted, but it doesn't matter because negligence is enough.
Did you have an accountant?
I'm sorry?
Was there an accountant?
Was there an account? There was a CFO. It was Daniel Mulclair. He's in the record and
Did
it's
you
in the motion.
do you have accounting records? Did you do tax returns and all those kinds of things?
Respectfully, tax returns will only tell us.
I'm just asking you whether
Yes.
you did.
Oh, yes, we did have tax
And then
returns.
there are underlying documents that go with those tax returns, right? Who did the tax returns?
I don't know the answer to that off the top
Did
of
you
my head.
ever ask that person whether they had all the underlying documents for which they could find the information that they put on the tax returns?
The answer I can give you, and while I
I'm
will.
just trying to figure out what you did.
Yeah,
so
no,
far.
I can tell you. We asked directly, where else can we find, we asked the CFO and we asked Harry Spring, where else can we find this information? We did ask. It is in the record. It's in the depositions. And the unequivocal answer we kept getting was, it was on the computer.
No, but I'm asking you, did you ever go to the accountant and ask the accounting, because you do taxes every year, you have enormous amounts of underlying documentation for the accountants, right?
Yeah,
Did you ever go to them?
we have not subpoenaed the accountant.
Thank you.
Thank you.
Your Honor, I don't have very much to add to the arguments that we made, other than just on the initial issues, just to state that, again, the issue we sought was liability. Any defenses that they may have asserted, they could have asserted at an inquest as to the arguments he's raising now. So we believe the underlying decision was an error. With respect to spoliation, Your Honor, it's quite clear. There's no final order below. We've made the arguments in our papers that the appellate court should presume on the appeal that the determination of the trial court is discretionary, and the court should be given significant deference to its opinions.
But ultimately, as you point out, it was denied without prejudice in this sense. Maybe the words weren't precisely used, but that's what happened. So presumably, all those issues with respect to spoliation, the issues my colleague is raising, whether the documents are available from other sources, that can be all hashed out in further discovery or at trial. And then appropriate relief can be given at that time if warranted, correct?
And the court will be able to determine whether you have the culpable mental state. So,
Correct, yes.
So no harm, no foul yet.
And again, Your Honor, my apologies. I didn't think it was this bad about my hearing and hearing, Your Honor.
Okay.
My apologies.
That's okay. That's okay. All right. Thank you. Yeah, I know. You got a minute. You got a minute.
My apologies. So, yeah, I think, I understand the court's point about no harm, no foul. I just don't think there was a decision down below on this issue, and I think that it was glossed over.
I think that's an unfair characterization. I think the court just decided that at that juncture, he couldn't make a determination based on what he had in front of you, and that's why it was denied without prejudice. So you still have remedies below.
Respect.
I mean, we'll see after you exhaust all of the places where all that information could be obtained, whether the court decides to do something else, an adverse inference charge, something else other than spoliation. That's in the court's discretion, and I have no doubt you'll you try to come up here after that event, right?
Well, it depends how it turns out. Thank you, Your Honor.
Right, I mean, you got to be aggrieved first, right? But
Thank you.
Arias?
Good afternoon. May it please the court. My name is Puichi Chang, and I represent the defendant appellant Sanitation Salvage Company. This is an appeal to reverse the lower court's decision. The lower court found or held that there were issues of fact, and our position is that there are no issues of fact. The plaintiff never once was able to establish that there was a piece of fish skin on the sidewalk before his accident happened. His testimony—
You mean seeing the fish skin on the sidewalk after he fell is not enough for—
No, Your Honor.
Wait, let me finish. For an inference that in the moments before he fell, that he fell on the fish skin, that's not enough?
No, Your Honor.
He has to see it beforehand?
And, Your Honor, there is a distinction between this piece of fish skin because it's a transient piece of object. It could have been on the bottom of his shoe that he got from the van he was driving. Could have gotten on—
I'm sorry, counsel, I'm sorry to interrupt, but that really sounds like an argument you'd make at trial. Because what we know here is plaintiff's in a van, your crew is removing organic waste, he backs his van up, and he slips and falls. Why isn't there enough circumstantial evidence to get to trial? That's all we're talking about, getting to trial where you can make those arguments.
Well, Your Honor, at the time that the garbage was being picked up, it was not organic waste. It was your paper waste. And the sanitation truck backed all the way into the bay, and it's a Packer truck. So the tail—
Let me stop you for a minute. Isn't there evidence in the record that every day the sanitation company came in the morning and there were two different trucks? So even though I know it's your claim that the truck that was immediately in the bay that people saw didn't drop the waste, there was a truck earlier that was moving organic waste that included fish guts.
That truck was on the street and not in the bay, and that's where the distinction is.
So from that, you think that we can just conclude that there's no issue of fact as a matter of law, that the sanitation truck removing the organic waste, which primarily consisted of fish stuff from a company that was involved with the preparation and sale of raw fish, that he doesn't get his day in court to prove that they're the ones who may have, in their duty to remove the garbage, have left fish waste that he slipped on.
And from the testimony of the parties, the company that would have moved those garbage pails from inside the loading dock onto the street is his employer, the lobster place. The sanitation company never touches those
But the lobster place, didn't the lobster owner testify? Didn't he say, gee, yeah, sometimes the sanitation company comes. I didn't see the waste that day, that they dropped anything, but sometimes they come, and when they remove the fish waste winds up on the sidewalk. He said that, didn't he?
No, Your Honor, he did not.
He did not.
He did not say that. The garbage that there would not be organic material dropped on the sidewalk. The organic material was picked up on the street. Now, separately, the lobster place, like you said, Your Honor, their job is to fillet fish and clean fish. So inside the lobster place, yes, there is organic material that is created from cleaning this fish. And that organic material could drop onto the floor of the lobster place. But that is not.
And only the floor.
I'm sorry?
All right, it's all right, I'm withdrawing the question.
Oh, sorry.
That's all right, I'm withdrawing the question.
So in any event.
No, I just think what you're asking us to do is a lot of issue resolution before there's a trial, and I just don't see as a matter of law that the sanitation company who removes the fish stuff can be let out of the case as a matter of law. That's my opinion. That's my opinion.
Then that would mean that any company that is being sued, and in this instance, because they are a sanitation company, then they would never be able to win summary judgment. And that's what Espinal is
I think it's
about.
hard for them when the other side raises an issue of fact. I think that is the law. You get a trial.
Respectfully,
Right,
Your Honor.
okay.
Thanks.
Thank you.
Good afternoon. My name is Evie Kazansky, and I represent on the second appeal SMHS, the owners of the property. So I think the court respectfully has hit the nail on the head. With respect to the owner, we moved for summary judgment on the grounds that we're out of the possession owner. I don't think anybody doubts that. The secondary issue with that was that because we don't have any responsibility for the allegations made by the plaintiff, therefore we had no duty in this instance.
But how
second,
about, don't you have a non-delegable duty to maintain the sidewalk in a reasonably safe condition?
Secondarily,
Under recent Court of Appeals case.
yes, I saw that. So what I would argue is secondarily, even if we had some duty, the real issue is notice. And I think in this case, what you have is everybody stating this issue of the drains. It's a red herring. The drains were this building was apparently built in about 2008, and then there's an issue of who put in the drain in the front. Then there was a violation in 2008 for overflowing, and skins and everything were coming out. And then if you look at the record, it's clear from the course of conduct between the owner and the Lobster Place. Lobster Place took care of this building. They took care of the drains, they hired people, and I think the plaintiff has conflated overflowing and filling a drain with fish scales with a defective
But
drain.
I could see a circumstance that fish scales and guts could go through the drain and come out. But the question is there any evidence that on the day of the accident, day before the accident, that there was a flooding condition or drains were getting clogged so as to maybe create that condition?
No, thank you, Your Honor. In fact, Mr. Barbioso, who is the manager, and even the witnesses that put in their own statements, basically say in the days coming up that there was no issues with the drains weren't overflowing, there hadn't been violations according to this record for at least 5 years, and that Lobster Place was continuing to maintain them and have Rocky change the drains, fix the drains, meaning the structure of the drain.
So,
And on the
counsel,
day of the
can
accident,
I just interrupt and ask you, with respect to constructive notice, did your client put in any documents showing when you last inspected or when that area was last inspected before plaintiff's accident?
with respect to constructive notice, it's always hard proving a negative. And I understand that the first department wants an inspection, but based on this record,
I'm just asking you, did you put in anything that would say, I didn't have constructive notice 3 hours before the accident, the dock was inspected and there wasn't anything, or
well, our first argument is it's not our duty to inspect that area, but secondarily,
you have a non-delegable duty, right?
it's on the
So I'm
sidewalk, and we
asking you
believe
about-
for
Yeah,
our, I've
please-
said no. I said no.
No, I understand. When she's asking a question, can you please stop
sorry.
and let her answer?
I just want to find out if you put in any records that would cover that.
They said that the last time they had been there was maybe a few weeks or a couple of weeks before that.
Okay.
And then with the witness, our argument with respect to constructive notice is that it was not there beyond maybe 5 to 10 minutes. So even if we had been there the day before, or
Right,
2
and
hours before,
You're
based on-
relying on the Lobster Place's visual, I'll call it inspection, but visual view of the drains that morning and the evening before.
and the testimony that nobody had seen this fish skin, I was going to call it something,
So in other words, right.
until after the trucks had left.
So
So when you talk about constructive notice, I do understand the inspection, and that's a very hard burden for a defendant. But in a case like this, when the testimony is nothing was there until after something else happens, the owner's not going to come that minute and be like, let's clean the sidewalks. And the last issue is the court also, we did move for contractual indemnification on the lease. And the court looked at it based on a construction. She looked at the wrong general obligations. Here we have two very sophisticated parties, an insurance procurement. The indemnification clause includes the adjoining sidewalks, and there's no negligence trigger for Lobster Place, and therefore we should have been awarded contractual indemnification based on the lease, irrespective of Lobster Place, who's not here, claiming that we might have had the duty to maintain the sidewalk. The indemnification clause covers this, and with the procurement is, it's not violative of the general obligations law for leases. Thank you.
Thank you.
Good afternoon, Your Honors. My name is Elliot Zucker from Aronson, Rappaport, Feinstein, and Deutsch on behalf of the plaintiff respondent. I think the court clearly understands our position, so I'll skip recapping my brief and go directly to a couple things that were just raised by the owner's attorney. The owner tries very hard in their brief to mix up the different drains that were in this building, okay? There were drains that were put in by Lobster Place as they were building the place out, okay? But the drain we're talking about at the edge of the garage came with the premises, okay? There's really no dispute about that.
Well, let's assume that's all correct.
Okay.
But didn't Barbosa testify that he didn't observe any drains that were overflowing on the morning of the accident?
Okay, but let me talk about Mr. Barbosa's testimony in full, okay?
Well, just answer my question before you do that.
Yes, I mean, look, I can't deny that he said that, okay? But now look at Mr. Barbosa's testimony in full, okay? Mr. Barbosa says that this drain, its overflowing is a regular problem, okay? To the extent that every 3 to 4 months, he says, they have to bring in an outside plumber to sort of pump it out so it can continue to maintain its purpose, which is absorbing the fish guts and debris. We submitted the plumbing records, okay? We know that the last plumbing clean-out was in January of that year, okay? This accident happened in May. He says you need to do it every 3 to 4 months for it to function properly.
Actually, February, right, not January.
I thought it was...
This day, yeah, it did it twice in 2010 and 11, 3 times in 2012, and then once in February 18, 2013.
Okay, let's say it was...
Which is 74 days before the accident.
Okay, but even so, he says every 3 to 4 months. February to May means it was either overdue or about due, okay? And I think by itself, that at least raises a question of fact about whether this drain would have been in a functioning position at the time of the accident.
But I don't understand. If the testimony is that it wasn't overflowing on the day of the accident, I mean, what inference can we draw from that?
But again, the fact that it may not have been overflowing at the moment he saw it, again, this is a continuing process as fish are cleaned, as the area is cleaned, stuff gets on the floor. The testimony is that they push stuff out into the drain. If he looked at it before stuff was pushed out into the drainage area, he wouldn't have seen an overflow.
Okay.
And at the very least, again, as I think has been said repeatedly, at the very least, this is a question of fact. The court may choose to disregard everything we're saying, but that's not where we are now. Thank you.
Okay.
Respectfully, Your Honors, with respect to whether there is an issue of fact, giving inference to the plaintiff in this instance, the reason not to give the inference to the plaintiff is that there is a slew of testimony from all the other eyewitnesses who all unequivocally stated that there was nothing on the sidewalk before the accident happened. And I would respectfully request that the court review the testimony and the affidavits from these other people. Thank you, Your Honor.
Thank you.
Very briefly, again, with the issue with the drain, I think Judge Singh has it correct. The issues with the drains were not necessarily proven to be a constructive, defective design as opposed to clearly just stuffing things in. And plaintiff wants to make that a recurring dangerous condition. And even if that was a quote-unquote recurring dangerous condition, in at least the few days before this accident, there's no issues, and at the very least 74 days before, there was no need to call back Rockies. And lastly, I just again want to focus on the fact that irrespective of what happens to SMHA's vis-a-vis the plaintiff, that contractual indemnification in the lease should have been granted to us. Thank you.
Thank you. Thank you all. Okay, Castellano.
May it please the court, my name is Michael Kazores on behalf of the appellant respondent, Park East Construction. As you know, there's many issues in this case. The first issue that we have to get out of the way is whether or not the Supreme Court abused its discretion in refusing to hear our motion for summary judgment because the handling attorney was late or did not appear for the oral argument. Both in the court below, on our motion to vacate the default, that was not opposed. That was not opposed by counsel on the appeal. So it's respectfully submitted that the merits of the motion should be considered. The next issue goes towards the substance of the motion for summary judgment by Park East. The first issue is the first three causes of action or negligence causes of action. Those causes of action should be dismissed as to Park East, and I would note that that argument was not opposed by any party below, either on the summary judgment motion or here on appeal. And there's no evidence that Park East controlled the means and methods of the plaintiff's work. Park East was not even present, and therefore any and all negligence claims.
Is this a means and methods case? Analyzing the 200 claim, is this a means and methods case?
I do believe it's a means and methods case, Your Honor.
What's the predicate for, how did the accident occur here?
The accident allegedly occurred when the plaintiff was assisting his coworkers unload sheetrock off of the truck that he was driving and putting it onto a dolly. It's alleged that one of the wheels broke on the dolly and that the sheetrock fell over and hit him, or that that dolly struck another dolly, which then hit the plaintiff. The accident was unwitnessed by anyone. The plaintiff unfortunately died from unrelated conditions before he was deposed, so we don't really have anyone's firsthand version of how the accident occurred. We do believe it's a means and methods case based on that description as to how the accident occurred. Given that Park East was not present, did not control the means and methods, the negligence causes of action should be dismissed. Regarding the labor law claims, Park East simply is not a labor law defendant. It is not the owner, the general contractor, nor its statutory agent that was assigned to supervise or control the means and methods of the plaintiff's work. For that reason, the 240 claim and the 241-6 claim should be dismissed, at least as to Park East. With respect to the 241 claim in addition, that cause of action was dismissed on its merits by Justice Bannon below in favor of my co-defendants, finding that there was no disputed issue of fact as to whether or not that cause of action was, whether or not that provision was violated. I submit that if the court below had heard our motion on that issue, it would have granted summary judgment as to the 241-6 claim for the same reason it granted it to our co-defendants. Lastly, on the contractual indemnification claims and all other cross claims asserted by our co-defendants, we submit that on our motion for summary judgment and now on appeal that they should be dismissed because the contract has a negligence trigger. We've already established that Park East was not negligent. Therefore, the contractual and common law indemnity and contribution claims should be dismissed. There's also a fatal flaw in the lower court's decision in granting a conditional order of contractual indemnity in favor of our co-defendants, notwithstanding the fact that Justice Bannon held that there was an issue of fact as to their negligence. It's a clear violation of the general obligations law to grant a party contractual indemnity or conditional contractual indemnity when there's an issue of fact as to the indemnity's negligence. Finally, the issue with regard to whether Feldman Lumber's negligence could be considered something that could be imputed to Park East. It's our position that it cannot be imputed. First, because Feldman Lumber was a subcontractor or a vendor or material man of Janus Industries, not Park East. And lastly, because as the employer of the plaintiff, its negligence cannot be considered at the time of trial, and therefore any negligence by Feldman cannot be imputed to Park East. Thank you.
Counsel.
Hi, may it please the court, I'm the owner general contractor in this case. First of all, there's no evidence of active negligence against the owner general contractor as part of my appeal. It's a means and methods case. The delivery of the drywall sub was through a company that Park East had hired, or an agent of a company Park East had hired. There's uncontroverted testimony that my client didn't own the drywall cart whose wheel allegedly failed. My client
Would that be a means and method? Couldn't it be, could it be both? It could be a defective condition?
No, there's legions of case law from this department, which I cited in my brief, wherein equipment of a subcontractor is not considered a condition of the premises. Plenty of cases I cited regarding Baker scaffolds, ladders, where this court has deemed that to be a means and methods analysis. So in applying the means and methods analysis, there's uncontroverted testimony that we didn't direct and control the work, didn't own the equipment, didn't provide the labor. Park East is a statutory defendant in this matter because the delivery of the sheetrock is part of the scope of work. And this explicit language cited throughout the brief, wherein they assume all the liability and supervision of this sheetrock delivery work. And there's side case law, the fact that the actual sub doesn't do the work, but has the authority delegated to the engine producing work is not dispositive of that issue. So as far as the one remaining issue in this case, the labor law 240 subsection 241, they would be vicariously liable for the acts and omissions of the plaintiffs, of the decedent's employer. It's explicitly throughout the contract. It says any agent, servants, or employees of the subcontractor for the purpose of contractual indemnity shall be deemed servants and employees of the subcontractor, Park East. The one sole case that Park East cites in support of its novel position just says that you can't have the employer on the verdict sheet for an apportionment. That's not what I'm asking for here. Indemnity is.
Well, I mean, a plaintiff can't sue Feldman Lumber, right?
No, he can't.
Right.
I'm only the only cause of action is statutory and vicarious in nature. And if it did occur, it occurred due to the agent of Park East sub whose acts or omissions caused this to occur. Either they didn't fail to secure the sheetrock on the dolly cart, or their drywall dolly cart was defective. And finally, my appeal deals with that the wrongful death claim should be tossed. It's too attenuated. They're claiming.
When did you first raise that issue?
I raised it in opposition to plaintiff's cross motion, and it was raised in Park East direct motion on the summary judgment. And so I raised it in reply, and I raised it in
Well, if you
opposition.
raised it in reply, did plaintiff have a opportunity to respond to it?
Yes, they did, because they cross-moved for their Labor Law 240 subsection 1 claim. And my opposition to that is, hey, there's no eyewitness to this. There's no eyewitnesses to the accident. And the decedent passed away before this accident occurred, so he's not entitled to the relaxed evidence of the noseworthy doctrine because the wrongful death was not causally related to this claim.
On the issue of whether the wrongful death was causally related to the accident, you say that there was an intervening cause of his death being his liver failure. Did you need an expert affidavit in order to sustain your burden on that, looking at the medical records?
No, I did not, because the issue of what caused the death is not in dispute. Plaintiff, in the bill of particulars, cites depression leading to alcoholic hepatitis death. So the issue of death is not in dispute. It's should this court, as a matter of law, should that be considered a proximate cause of the wrongful death, or is that too attenuated and his decision to abuse alcohol an intervening, superseding cause that's not at all too attenuated to be related to this accident that happened 10 months prior?
Okay. Thank you, counsel.
Thank you.
Your Honors, regarding the so-called wrongful death cause of action, we're talking about the second cause of action, which was asserted specifically on behalf of the decedent and alleged his conscious pain and suffering. It's our position, and I think it inures to the benefit of the co-defendant as well, is that on its face, this is not a wrongful death claim. It's a redundant negligence claim which pleads conscious pain and suffering on behalf of the decedent. That, by definition, is not a wrongful death claim, and I cite the case law in my brief. Regarding whether Park East is a statutory defendant, as my colleague had mentioned, it's clearly not. Park East, regardless of what the contract may have said, the reality is that Park East did not control the means and methods of the plaintiff's work. It wasn't even present at the time. It didn't even hire the plaintiff's employer. It didn't even know that the plaintiff's employer had been hired. We were simply a carpentry subcontractor that was doing work in the building, and the plaintiff was injured delivering sheetrock. That does not render us a statutory defendant liable under the labor law. And for that reason, we believe that the decision should be reversed and summary judgment should be granted in favor of Park East. Thank you.
Thank you. Thank you both. Yeah, you get 1 minute on, no, you don't, because no, I'm sorry, you do. I'll give you a minute in rebuttal.
Real quick, my response to that is, first, they knew Feldman Lumber was the agent of the company they hired to deliver this material, because with every invoice that they received from Janus Industries, there was attached a corresponding Feldman Lumber invoice, which their principal authenticated at his deposition. And second, that's immaterial. The contract's pervasive in that you have complete supervision and will bear liability for any mishaps that happen during the course of the furnishing of the materials, the furnishing of the sheetrock. And also, I once again refer to the brief for the case law that says if you are delegated the authority over the injury-producing work, which this sub was, the fact of whether or not you exercise that authority is immaterial in considering whether or not you're a statutory defendant under labor law. Thank you.
Thank you. DirecTV?
Time is running.
Afternoon, Your Honor. David Cole from Texas, and it's an honor to be here in this very beautiful courtroom this afternoon, live, no less.
What happened to Paulette Miniter?
She left our firm, turning down the chance to visit this courtroom, so I seized the opportunity.
Her loss.
Her loss, my gain. So you'd probably like her better, but I'm the luck of the draw today. And in my time with you here, I wanted to speak to the issue of justifiable reliance. It was our first issue in our reply brief. There are other issues presented about what's a misrepresentation, what is not, what is actionable, what is not, but justifiable reliance is a standalone element of this fraud claim, and it is one that serves a distinct recognized purpose, which is to restrict a claim, and this is a quote from the Court of Appeals on this issue, when a sophisticated business person or entity claims to have been taken in. And we know precisely here the subject matter on which DirecTV says it was taken in. It says in its brief several places, unambiguously, quoting the trial court record, that it would never have agreed to this particular fee that is in dispute if there had not been concealment, alleged concealment, of the impending loss of this station's NBC affiliation. But the record, the pleading, is silent on anything that was done by DirecTV to test how long, how good, how strong this station's NBC affiliation was. It is a sophisticated...
Let me stop you for a minute, and I'll accept they were a sophisticated party, but was there any due diligence that they could have done which would have revealed to them that WHAG only had a limited time on its continued affiliation with NBC?
So the record offers two insights on that. On their pleading, it offers nothing. They don't say there was something, that they did anything in particular that would have illuminated this issue. But what they offer in their briefing is evidence from discovery on the claims, as the claim has gone forward, where they complain that there are issues about confidentiality that have come up in discovery that have made it more cumbersome to get discovery of these instruments than they might otherwise like it to have been. If that had been the answer to the question, hey, tell us something about this affiliation, is it good? And our response was, those are confidential. There are issues about disclosing them. That'd be a whole nother ballgame on justifiable reliance. Maybe that's a risk that's worth running. Maybe it's a risk that's not worth running.
But it wasn't in the public domain. They couldn't otherwise get this information unless you provided it to them.
The record does, they don't plead anything about that, but they would have had to have asked and then put in motion a process by which some information maybe could have been brought to light. We don't know, because we don't know what they would have asked, how they would have asked it, what they would have focused on. We have some intimation from discovery that has taken place since this ruling that there would be some challenges, there would be some confidentiality issues, but that doesn't mean they're excused from asking the question or that no answer might be material.
If the special knowledge is within your possession, right, why would it even occur for them to ask?
Because they have to do something.
And I want you to think about the context of where we are, why we're here today. We're here on a motion to amend.
Right.
Not on a motion for summary judgment, not even a motion to dismiss.
True.
So they are, those arguments might be stronger down the road, no?
Understood, and there is more discretion that comes into play here, although I believe it's a question of law. But we cite the Centro Empresarial case, my apologies for the poor pronunciation, Centro case in our briefing, where there was information solely in the possession of the other side about the financial performance of a company necessary to execute
But Centro was in the context of summary judgment, wasn't it?
True, but the fact was that they never asked.
So, well, but that's different, right? Summary judgment, there's some obligations on the part of movement and in response to create a trouble issue.
In the right case,
here we're
sure.
talking about whether the proposed new claim is palpably improper or insufficient as a matter of law. And we have held, I mean, this department, it's freely given Never deny, we never substitute our judgment for the trial court unless it's like totally bold.
That's this court's, you are free to make those decisions and check the trial court's discretion as you wish. I just think that the cases that inform this issue, while some do come from summary judgment, say when you do nothing, there is no claim.
Yeah,
And
but
if you do, you're not gonna do
you've
anything
got,
more.
the procedural posture is where it's at. Because we have to accept everything that this says right now and see, could this possibly create a claim? It's not whether, I mean, you could make that motion on a 3211A7 or a 3212 motion. That's a different procedure and a different standard.
I wouldn't advocate this today if there wasn't a reason I thought it was a valid argument as a matter of law. Silence is silence, whether it's today, summary judgment, or
No, I mean, we don't think the argument is frivolous, so you don't have to
Yeah.
worry about that. What we're saying is, this court will never, in a de novo evaluation, substitute its judgment for a trial court in this context. Because you're gonna have summary judgment, and eventually you're gonna come up here again. So, you know,
I respect
we can
that.
deal with it at that point.
I respect that. Pleadings say what they say, and I'd ask the court to give them a look.
There you go. Thank you.
Your Honors, may it please the court, John Pressman for Haynes and Boone, representing DirecTV. I don't have much to add, Your Honor. Mr. Chief Justice, Justice Singh, Justice Scarpulli, you hit the nail on the head. We're at a motion for leave to amend, which is to be freely given. And they have a very heavy burden to overcome the validity and the presumption of validity in our claims. I do want to correct two things that Mr. Cole had said on his argument. And the first is that there's nothing in this complaint about the lack of availability of this information to DirecTV. That's just not true. We actually make those allegations several times throughout the complaint, paragraph 20, 21, 25, 59, 62, multiple times.
So the question is, did you ask them for it?
So,
Pre-signing the agreement, did you ask them?
so we did not ask the specific question about DirecTV. We asked a lot of questions in due diligence about changes to.
Did you ask about any of them when the?
Sure. We asked.
So why not this one?
That's an absolutely great question, Justice Scarpello, and let me come at it this way. This was not our first trip around the track with Nexstar. What they failed to tell you is we had had negotiations with them for years about the same type of contract. This was a renewal. So we came to this as an educated consumer, knowing exactly what we could get and what we don't get. And that has been confirmed by their general counsel, who said, and I would direct the court to the record 156, said when she was deposed, we don't give that information out. It's confidential. They don't cite to a single.
Did you ask for a rep and warranty on that information? So you know that you're not going to get it. Did you say to them, I want a representation? I mean, normally what one would do in that situation is say, I want a representation and a warranty that these aren't going to end at that period of time. Did you do anything like that to cover that?
So in answer to your question, Justice Scarpello, we did not, and the reason is those were never given.
I agree.
But let me also say
we're
this.
on a motion to amend,
Yeah, it's a motion to amend, of course, and so that really is the scope and the backdrop against this which must be weighed. I would add one thing, though. What we know, what's come out, what was before the trial court is, it is so incredibly rare that a network loses its affiliation. Their own experts said between 2010 and 2018, it happened a total of 16 times across 1,300 to 1,400 stations across the country each year. That is 0.0001% of the time. So we didn't ask for that. We never get that. They've actually confirmed that, and that's where this should end. Thank you.
Okay, thank you. Okay, counsel. I'll give you. More questions on me. I'll give my time. Thank you. Thank you so much, and I hope you had a pleasant stay in New York. Take care.
Spirited. Don't worry.